Chaile time. Hello and welcome to this week's episode of Chaile Time. Toby, welcome, and how are you?
Near Kanama, it's going very well today.
You're in a good mood.
I'm in a very good mood.
What's happening? What's happening in your world?
Well, first of all, we won a very long CCMA case. It took us about a year. But secondly, I'm now getting involved. Well, we got a new client, so we're now involved in a interesting case. And Tsepo, sometimes you sit at the CCMA. No, not sometimes. Very, very rarely, though, do you sit in the CCMA and you're like taking out your popcorn and you're like really enjoying this. So I had this. We got this case down. Okay, it's an in limine process at the CCMA in Pretoria. So we initially didn't get a 711 form, nor the condemnation application, because, it's an eliminate process, so there's going to be, the employees filed a condemnation application because they're late. The actual nature of the dispute, we have no idea, because we didn't get a 711 form or the condemnation application. Anyway, so luckily, we managed to get a set-down notice from the CCMA like 2-3 days before the set-down, so we could see this is an operational requirement dismissal dispute. Interesting. So we couldn't really oppose, but anyway, so I went there myself in person.
Yeah.
And here there was a union they're representing 61 employees. So you had like 15 of the staff also there. But now, interesting, Tsebo, I explained to them I never received the information. We later found that they misspelled the email address, so we never received a 711 form and so on. Okay, but anyway, so then the commissioner took out the condemnation application, but it's a thick pack. I'm like, whoa. So anyway, so they allow, or the commissioner out of his own said, listen, why don't we postpone? Because clearly, I've got no idea what's going on in this thick pack of condemnation applications. So I appreciated that. But then afterwards, and the union was extremely friendly. One of the major unions in South Africa, very friendly.
For a change.
And I was just like,
you were shocked.
Hulle sê Afrikaans sê, well, rookie is daar 'n vuurtjie, So I'm like, what is going on here? I've never seen the comrades being so friendly and accommodating and whatever. Anyway, but now it's CCMA Pretoria there downstairs. There's a little coffee shoppy there, you see. So I couldn't control myself. So I bought a coffee and I just sat and I went through the condemnation application. And then at one stage, I just laughed so loud that everybody was looking at me. This case is 4 years and 8 months late. This is a massive retrenchment that happened in 2020 already.
During COVID.
Because of COVID, the company, it was locked down.
Yeah.
Okay. And so they end up dismissing over 100 staff, like 2/3 of the workforce. But now what was so funny is in this condemnation application, they now have to explain their reason for lateness. Now, just on the actual retrenchment process followed, everything is fine. It was a Section 189A process, facilitated, 60-day consultation, 4 consultations. As far my opinion is concerned, solid, no problem there, okay? Yeah. But now the employees or the union must motivate the reason for lateness. They appointed one of their... Now, this whole condemnation application is about WhatsApps and emails where officials argue among each other. So what happened is they handed the case over to some kind of legal department official who deals with the labor court. Now, this matter must go to the labor court, okay? Yeah. Because it's a large-scale retrenchment. So they filed the case at the labor court. And the entire condemnation application of 4 years and 8 months of evidence of where they're trying to get this guy to follow up. Where are we with the case? Give us the case number. And this guy say, I'm just in a meeting. This is now the union official saying, I'm in a meeting. He's playing hide and seek. Once I'm done with my meeting, I'm coming. I'll give you the case reference number, and then I'll do it by tomorrow, and tomorrow will come and go, and it didn't give. And eventually it went on for almost 5 years. So eventually they report this guy to his boss. And this boss then also start ducking and diving, not answering, not welcoming them to make meetings with him, or whatever the case may be. Then almost 5 years later, they decide to follow it up by themselves, and then they realize that the case was never filed at the labor court. And that is where I start laughing. It was like a soapy. You just read the thing, and eventually you're like biting your nails, like, what is going on here? What's going on? Eventually, they never filed at the labor court. And I'm like, oh my goodness, this is so good.
So why did they go back? Oh, now the employees doesn't know what.
I don't know that for a fact, but typically I don't think the employees will know the legal jargon as to what's not really happening here or not happening here. So why are they now back at the CCMA? I've got no idea. Maybe they're just trying to play to the theatre. Maybe they're trying to show the staff they're doing something. I've got no idea. But this matter must go back to the Labour Court, and they must go explain to the Labour Court why they're late, you know. But now the problem is this can be malicious, you know. Now cost orders come into play. So they are what is called between a rock and a hard place.
And they have to answer to their members.
Yes, they have to answer to the members, you know. This is a typical example of negligence by the union.
Yeah.
And worst case scenario, the staff can actually sue the union civilly for messing this up so badly, you know. So look, and the comrades are friendly. I'm like, what's wrong with you guys? Why are you so friendly? Now I understand. They're really trying to somehow open a CCMA case here. But they know the CCMA don't have jurisdiction.
Of which, when you come back and continue during your continuation, the commissioner, and you also gonna raise a jurisdiction.
And the thing is, some of the staff already, historically, they were like 147 days late at that time. They were not union members. They tried the same thing, tried to apply for the CCMA condemnation. The commissioner just threw it out and said, they didn't have jurisdiction. You must now go to the Labour Court, Papa. Bramfontein, you know.
Okay.
And yourself?
I'm good. Nothing hectic. Not traveling for the past 2 weeks.
Yeah. Feel like you're on leave or something. You're not working. There's nothing for you to do.
Really?
No, it's not the case. I know.
Okay. Yeah, no, I'm good. Anyway, what are we talking about today?
Fixed term, or is it permanent? Employment contracts, should it be fixed term or should it be permanent?
Are we going back to the project-based contract?
Project-based. So we've mentioned it previously that we were busy with this case in the Secunda CCMA, where, how many was it? 17 employees. Their fixed-term contracts, which were all project-based, came to an end. They were told to apply for new positions. There were 7 positions available. They were told by the union not to apply because they thought the contracts were supposed to be permanent contracts, and therefore it was not necessary to apply considering you've got a permanent contract. But these contracts are all...
Can you share a disclaimer before you finish?
What disclaimer?
The views of this podcast is not targeted to any union or any...
I'm not saying the names of the comrades.
That is the second time now you're mentioning unions, and then...
But it's just the facts of the case.
And they are shortfalls.
The union told them not to apply.
I'm just joking.
So then they went to the CCMA to attack this case, and finally we got the award 2 days ago. The client sent me the award over the weekend, and so we won the case. So it was ruled there was actually no dismissal. Okay, so previously we mentioned, in a previous podcast, that how employees are sometimes prejudiced by the unions giving bad advice or so on. But this podcast is not focusing on that. Today we want to address some of the legal challenges around whether an employee was really on a fixed-term contract or should he have been on an indefinite contract, and dotted line, therefore he is actually indefinitely employed, even though he may have a fixed-term contract. So we're trying to address those challenges. Now, something that's interesting is this situation we had in this CCMA case. We've got clients in another province with the same union, and it's interesting how they're all on this kind of work work where you are working on mines or state-owned enterprises or so, which are typically project-based, they all argue the same thing. If you do maintenance at a mine or state-owned enterprise, then the actual work is indefinite. It's a permanent maintenance contract and not really a temporary project like the employer will typically say. And I see they all argue the same thing, so which make me to believe now it seems to be a strategic decision or idea by the union to say, listen, all these kind of projects, this is how we deal with it from a legal perspective. Because I see that the union officials, they use the same language. They all will say, no, this is not a temporary fixed term project. This is an indefinite maintenance contract.
Now, remember now this. The workers are employed by a certain company which is rendering the service to the state-owned entity or to the mine. Now, what is the agreement between the service provider who employs the workforce? What is the agreement between the service provider and the mine or the state-owned entity?
This is interesting because this is where the issue is from a legal perspective. In that contract, first of all, it's a fixed term contract.
Yes.
And it will typically say it's project based. So they will either say something like this is for a specified time, let's say for a year or for 3 years, whatever the case may be, or it's based on the duration of a specific project. But there's a trigger in there, there's a clause in there, it's called the automatic termination clause. And that clause typically says something like, your employment is linked to this project, and once that project terminates, your employment will automatically terminate, and this does not constitute a dismissal.
Or it can be terminated prior to the...
Or it can, prior to the termination of the project, based on whatever conditions from the client or whatever the case may be. But this is the thing, and this is also where the unions are coming in. After the termination of that project, probably in most cases, the actual work continues. So you'll find a service provider who's employed or recruited by a client to work there for a year. Now the year is come and gone, the service provider is gone, they go out to tender, they get a new service provider in to do the same work.
Yes.
So to what extent is the nature of this work really temporary, and how do you give somebody a fixed term contract if the actual work is ongoing? That's why the unions are saying, but listen, this is a permanent maintenance contract. It's not really a temporary arrangement. And this is where the issue is coming in. And, where some of the problems also suffice is that you now, for instance, get a service provider who provides a service to a client company, maybe on a project for a year or two, and then one day the client decides, I don't like that person. His project came to an end. Or his part is, we're talking about a specific employee now. Yes. Maybe there's 100 employees, there's one specific employee or 10 specific employees who are not performing well or whatever the case may be. So at the will of the client, they now say, their participation to the project came to an end. Now that triggers an automatic termination clause. But the project didn't really end.
What does the law say? Or how do...
Now, I'm building up to the law now.
Yes.
You see, now I want to do the third layer here.
Okay.
Because this is a very challenging concept in law. Because there are the correct way in doing this, and then there's the incorrect way in doing this. But I first want to put it out there to our audience, to those that are listening, okay?
Yes.
So let's say us now, who's a labor law company, HR company. Let's say we get a new client and they say, look, they want us to put somebody there 2-3 days a week. It's a tender. The tender is, let's say, for a year, as an example. Now I employ somebody, I put him there. Is this person now employed on or can I now put him, or let's say I put him on a fixed term contract for that project there. Is he now really employed on a fixed term basis because there's a temporary project there? Or is he employed by me indefinitely and he works for us and I just happen to put him there? So when that contract comes to end, then I'm putting him there or put him somewhere else. Or maybe follow the Section 189 retrenchment process. Now, the thing is this, the automatic termination clauses bypass Section 189. Because if there's an automatic termination clause that's triggered, that does not amount to a dismissal per se. It's just a termination. It's an expiry of a contract. Like you make a loan at a bank, you've got a 6-month contract with the bank. At the end of the term, it just expires. Nobody fired you.
Yes.
You see, it's the same concept. So is my employee then on a fixed term basis for that fixed term contract, or is he employed by me indefinitely and I use him wherever I want to and I just happen to put him there? Especially considering he's maybe working 3 days a week there and the other days I put him somewhere else. You see, it becomes messy now.
Yeah, no. Once you start putting him somewhere else, then the scope changes because he's no longer based on that project that you agreed upon, saying you're going to be there for 3 days. Because you want to cover the 5 days now.
Yeah, but you see, it's messy. It's not so,
Yeah, it's not a clear cut.
An employer will get a contract from a client. It's simple. We put the staff in a fixed contract there. But now life happens. Now, if I can dotted line, it's like an independent contractor. You employ somebody as an independent contractor. Technically, it's not a employee.
Yes.
But as time go by, he must apply for the permission to go on leave. Suddenly, he gets 21 days leave a year. When he can't come to work, he must get authorization first. Somehow, that relationship starts smelling like an employment relationship.
You give him the tools to work.
You give him the tools, the laptops, everything. Yeah. But 3 years later, when the company's business is going down, oh, I remember you're not an employee. Bye-bye. It's the same thing here. Are you not employed for a legitimate project? Or are they employed to you and you use them as an employer wherever you see fit? So, okay. The whole issue, the key issues, so let's just go a bit up and explain the legal challenges. We have a case law, by the way, Zengzile November versus Chaile Mining Solutions, which is a labor court case. And they also cross-reference Maglamu versus CCMA. So we're going to deal a bit about what happened in that case, and they will give us strategic direction. And I must say to the audience, if you can find this case, actually, I think we need to add this case at the bottom. This is quite a special case law. It really explains his concepts well, but what I like about this case law, this judgment here, at the end, the judge actually gives step by step 1, step 2, step 3, all the steps a decision maker should ask, all the questions they should ask in determining whether this is a real fixed term contract or not. So I like this one. There's guidance here. So I will add this one at the bottom, and then you can download it and go for it. So the issue here in law really is that automatic termination clause. Because once that automatic termination clause is triggered, there's no dismissal. That means the LRA does not come into play. It does not apply. Because if you want to exercise your right to challenge the fairness of a dismissal, you need to do this based on law. But if there's an automatic termination provision that are triggered, technically there's no dismissal. There's just an expiry of a contract, which bypasses this. But now the legislator is quite clever. They said here in Section 5 of the Labour Relations Act. Let us go through this quickly. So I'm just going to touch on some of the relevant issues here. Okay, so no person may discriminate against an employee for exercising any right in this act, okay? No person may do, this is now subsection 2b, prevent an employee or a person seeking employment from exercising any right conferred by this act. So every employee's got a right to whatever is written here. And one of those rights are to challenge the fairness of a dismissal. Yeah. Then it continues, subsection 4. A provision in any contract, whether entered into before or after the commencement of this act, that directly or indirectly contradicts or limits any provision of section 4 or this section, which I just read now, is invalid, unless the contractual provision is permitted by this act. So, this is the issue, Chaile. How can you have a provision in a contract that deny an employee's right to challenge the fairness of a dismissal in terms of this act? That's what the automatic termination clause does. in principle, those clauses are illegal.
Oh. Because nothing can foresee or oversee what is written.
You can't put something in a contract that deprives a person of his LRA rights. You can't put in a contract now you don't have the right to join a union. Because the access you have, freedom of association. So, but okay, let me help you out here. But before we do, there's also Section 198B. Section 198B it regulates fixed term contracts. Okay?
Yeah.
The purpose of Section 188B is to create job security, to enhance permanent employment. But it gives an exception to permanent employment. And there are 9 factors that you can use to justify why a contract are fixed term. So there's a very small window of opportunity in the law where a termination will not constitute a dismissal. Okay, and we're looking at subsection 4. I'm not going to go through subsection 4. There are 9 elements there that will, if that is the reason why you put someone in a fixed term contract, it will find then that it is a legitimate fixed term contract, meaning in such cases an automatic termination clause will not constitute a dismissal. It will just be an expiry of a contract. But the key for me really is Section 188B subsection 3 that says an employer may employ an employee on a fixed term contract or successive fixed term contracts for longer than 3 months of employment only if A, the nature of the work for which the employee is employed is of a limited or definite duration. So here's the first key. Also, just FYI, this specific provision, among others, are applicable to those earning below the earnings threshold, okay, which is probably by far the majority of employees, especially contracting companies to state-owned enterprises anyway. So anyway, the key there is you now look at the nature of that employment, of that work, is really temporary. So now you have a company, they employ an accountant, but they want to check them out on a fixed term contract for 3 months. No. The actual accountant, they always need an accountant. The actual nature of the work is permanent. You don't give him a fixed term contract. So when you look at the actual nature of that task, let's go back to state-owned enterprise. No?
Probationary contract.
No, man. That project at the state-owned enterprise, is it really of a defined, definite, temporary nature?
Yeah, if there's maintenance on the railway line, there's going to be maintenance every day.
There's going to be maintenance every single day.
Yes, because they move from place to place.
Yeah.
As long as there's a railway line there, should they get to the end, they're going to have to start again, refill the concrete, make sure that those bars are straight and what.
But that's where it's becoming difficult because there's no black and white here. There's no rule that says this is how it is. We're going to get there a bit later, but this is where you need to do a value judgment. Every case is based on its own circumstances. Like, like your example now, if you're doing maintenance at a railway company, it may be that there's really just a specific project, or it may be it is just ongoing and it's the same thing over and over and over. Then it becomes questionable whether it's really temporary. The nature of the work is really temporary. You see, it's becoming complicated. So a fixed term contract is not legit just because the client says so. It's legit because the nature of the work is temporary. Because the laws say you can give a fixed term contract when either on a specified time or a specified event or project. Anyway, let's continue. So in Zanzili, this case we're busy with now, they cross-reference Maglamo. I want to read this. It says here, parties to an employment contract cannot contract out of the protection against unfair dismissal afforded to the employee, whether through the device of automatic termination provisions or otherwise. So that just confirms Section 5, okay? In Maglamo, the client company instructed the service provider to reduce headcount. Staff were elected. This was considered an at-will termination by the client. So now you have a project at the client. But during this project, let's say this project is 2 years as an example now. In the middle of this project, the client now say, listen, we're cutting heads. We want Yanni, Susan, and Tabo. They must go. Now that termination is now not linked to the project. It's linked to the will and desires and the needs of the client. It doesn't mean the client is now wrong. Remember, we're not talking about the client here. Yeah. The client do what they want to do. The question is, how does the employer deal with this?
Service provider.
Because they've now got a fixed term contract, which is project-based. The project is still not finished, but now there's a reduction in headcount. Now it triggers that automatic termination clause. But does that now unfairly depriving the employees from the right to challenge the fairness of the dismissal? Because this is now based on the feelings of the client. It's not actually linked. And this is where a project's got its own identity. There's a start and there's an end. If the termination is linked to that legitimate termination as provided for in terms of that project itself, then there's a greater possibility that that will not constitute a dismissal. But now the at will, and in this case the employer actually lost the case because this was an at will termination by the client. So what it means is the employer should have followed the Section 189. It doesn't mean you can't get rid of the stuff.
Yes. Yeah, no, I understand, because there will be questions like what criteria did they use?
And maybe now there's other branches, can't we maybe bump some of those stuff? I understand 189 can become messy, bit complicated, but that's the issue, okay? The termination of the employment contract was not linked to the attainment of a particular goal which can be objectively identified. So you have a project, there's a goal. This must be achieved as part of that project. Once a goal has been achieved, project done. Now you're terminated.
Yeah.
So question you ask yourself in this case now, the client reduced staff count, but it was unrelated to the project itself. It becomes difficult. So at-will terminations cannot be equated with other types of event that may bring a contract to an end because the contract was demonstrably served its inherently temporary purpose. So what I'm saying is, if there's a project that came to its intended end, it achieved its purpose, then that project terminated. Typically, a fixed term contract linked to that specified event will then automatically terminate. Fine, but that is basically the key. So I want to explain what I consider as an event. Here's my definition. An event is an objective event or project that typically has its own identity. It typically has a demonstrable end and a specified goal. So it is not a relationship between an employer and a client company that just continues indefinitely, and then at the will of the client, now we terminate staff or whatever the case may be. There's an end, there's a start, there's an end. There's your identity, there's your goal, there's what you want to achieve. Now to come back to the case we just won in Secunda, even though the maintenance is always ongoing, actual maintenance is linked to specific projects. So you, for instance, get maintenance in general. And this is where the unions will typically misconstrue how they put this. So every year, there will be a certain scope of what must be done. Yeah. They will then find a service provider to do that work for the year. At the end of the year, the project is done. The state enterprise will then re-look and say, listen, what other maintenance must be done? Oh, okay, we must also do that. So maybe in year 1, you must build a dam. Now the dam is built. Now year 2, you must maybe clean piping. So the actual identity of the project changes. Even though it is under the umbrella of maintenance, the actual project changes.
That's why sometimes it will have a project code.
It will have a project code. We are this year, or in this cycle, we are doing the following. And who knows, maybe there's no more maintenance thereafter. But given the nature of state-owned enterprises, there will always be some form of maintenance. But the identity keeps on changing. And it can be that after the contracting period, the goal was not achieved. Now they can extend it for another 2 months or 3 months, whatever the case may be, until the goal was achieved. And then, if they are happy with you, then they will go out. You may get the new project, or they will find a replacement, a competitor to do the work.
Now, the question, and it's very important, the question will be, let's say now, building the dam, contract dam C3 for 75. They are done building the dam. Now, contracts end. But now, they're going to do the piping. Is it important to make sure that you issue new contract that states that now you are moving from the dam to do the new piping system?
Yeah, of course. Because remember, your fixed contract is linked to that project. You must now get a new contract to say, listen, this project code 1, 2, 3, 4 is done. We're now 5, 6, 7, 8. New project.
Are the service provider
I suppose you can do an addendum too, the formalities as to whether it's entire new contract or just an addendum, that's probably immaterial. But the fact is there must be a new agreement.
Yes, the question is, are they doing it?
Well, in our case, in the Secunda case, yes, it did.
Okay.
The administration was
proper.
Spot on,
Okay.
no problem.
Now it makes sense.
No problem. Every year they will get new contracts. But the problem is, some of them have been getting new contracts for like 9, 10 years already.
Yes. Now that's what your unions are looking at and saying, but
it's ongoing. Yeah, but what they're saying is the maintenance is ongoing.
Yes.
But what they very conveniently choose not to disclose is that the actual nature of the work keep on changing.
Okay.
Anyway, so employees typically link to that event. So the employees link to that event. Now you must be careful as an employer to start using employees in other contracts. Now this is where it gets messy. Now remember our example, we put somebody at our client for 3 days a week. The other days of the week, now I'm starting using him here and there, wherever. Now the question is, who's he not really working? Well, he's working for me, but is he working for me on a temporary basis? Or is he working for me on an indefinite basis?
He's working for you on an indefinite basis.
He probably is working for me on an indefinite basis, and I happen to use him there. And then I use him there. So, and you'll find that even this Maglamu case, you'll put someone in a project, and eventually he doesn't work on that project anymore, he works there. And when this guy cancels, oh sorry, your contract is now also cancelled. But you're no longer working there, you're working here now, you see. So you need to be sure as an employer, if you employ someone on a project there, that's where he works.
Make sure.
He works there, on that project, for a specified time. And please have your paperwork sorted out. If it says the project is for a year, put it on there for a year.
Yeah.
And put the name of the project down. Okay? So, at the end of the day, there's no fast, black and white, clear rule of thumb of how you're going to determine these matters. So what the courts are saying is, you need to do a value judgment of a whole list of factors that can help you to understand whether that automatic termination clause, whether it's legitimate or not. So let's just go through some of what the learned judge said here. While the legal considerations for the policy against permitting automatic termination of employment are set out in detail in Maglamu, it is a difficult test to apply in practice. In my view, the analysis of the application of the principle in particular cases can be approached by considering if the automatic termination provision will be triggered by an objectively demonstrable event, which is not merely a function of the contracting party's will, and that the purpose of having such a clause is a justifiable limitation on the employee's right to challenge the fairness of a termination. So the termination is not based on the will of the client. There's a goal that was achieved and can be demonstrated. A situation where employment is deemed to end on a predetermined date or on the occurrence of a well-defined event that can be objectively determined and which is not merely a product of a third party's view will generally be less susceptible to being disputed for the reasons stated, but it will always depend on the particular facts of the case. So if it is specific, start, end, there's a specific goal to be achieved, it can be demonstrated, you will probably be safe. It would be necessary to determine whether in the circumstances of a particular case the clause was intended to circumvent the fair dismissal obligations. imposed on the employer by the LRA and the Constitution. Some of the relevant considerations, in my view, would include the precise wording of the automatic termination clause and the context of the entire agreement, the relationship between the fixed-term event and the purpose of the contract with the client, whether it is left to the client to choose and pick who is to tender the services under the service agreement, whether the clause is used to unfairly target a particular employee by either the client or the employer, whether the event is based on proper economic and commercial considerations. The list is not exhaustive. Each case must be decided on its circumstances. You have to look at it holistically. Ultimately, the question is, if you take the circumstances into consideration, the employment contract, the commercial rationale behind it, does it unfairly bypass or deprive an employee from exercising his LRA rights? Or is this a legitimate expiry and termination of a contractual agreement? Therefore, there's no dismissal. And that's a valid judgment that must be made.
Yeah.
So, look, the judge did mention 5 steps for commissioners and I suppose decision makers to take into consideration. I'm just going to mention them here quickly, but the judgment is in the actual description here at the bottom, so you can just follow it there. So, steps to be followed by a commissioner in a dispute about whether the termination of a fixed-term contract amounts to a dismissal or not. Now, step 1, consider the employment contract. With other words, the wording of the contract and the clauses inside. Consider whether Section 198 applies, because in terms of Section 198, there's a very limited scope to use a fixed-term contract, because the purpose of 198 is to promote indefinite employment. 3. Consider the events giving rise to the termination of employment. With other words, what triggered that clause? Is it the at will of some manager in a bad mood? Or is it because the project really came to an end? It achieved its goal. Step 4. Consider the effect of enforcement on the employee's statutory rights. And step 5. Consider other issues that may affect the final determination of whether dismissal occurred. Some other considerations will be Section 186, subsection 1, that deals with whether there was a reasonable expectation created to renew a fixed-term contract. So you have to apply your mind to all those factors too. So that's basically it for today. Fixed-term contracts. It's not always so easy. I know for an employer it is. For a CEO it's very easy. There's a fixed-term contract, client cancelled, done, no problem. But we in HR, we're like sweating, like just...
Yeah, and then how do you interpret it to that person who's been working there for 4 years and getting renewals every year, and then boom, on the 4th year you're telling him that...
where the sweat come in for us HR people? Normally at the CCMA, it is this union and 100 others. and this is what, like a year later, now you must re-employ 100 people. Then the CEO is angry at you. But you couldn't tell him back then, hey, we must just maybe slow down,
See, that's why I was pointed to the finger and said...
I've got a case like this, similar case in another province. Last week I had a meeting with a client, the operations director. Now, we're giving the union 2 days. We give them an addendum to the contracts, 2 days, then we continue. It's been a week now. Yesterday I got a WhatsApp. I thought, there was a timeline. So I'm like, don't worry, tomorrow I'll give letters. If the union don't accept the addendum, I will just issue letters. But the thing in my mind is, I know for the employer it is simple. There was a deadline, we need to make this work, but I'm the one facing them at the CCMA. Exactly. And then they want to see if there was a good faith engagement with the union, you see. So for the employer, 2 hours time is very reasonable, but not for the union. The employer wants things done now. You see.
They don't have tomorrow.
They don't have tomorrow, you see. And I'm in the middle here. So I need to manage both sides now. So I've given the union a reasonable time. It's past their deadline already. So today, they haven't given me a response. So I'm going to give them a letter to say this is not how it's going to be. But in the meantime, I've got the employer on my back. You see. But then a year later, if I go to the CCM and I have to re-employ or compensate all these people R1 million or whatever the case will be, why did you not tell them? Then they fire me, you see.
Anyway, that's all for this week. Thank you very much. Thanks for watching. See you next week. Bye-bye.
Awesome. Bye-bye.
Good morning, everyone. Let's have a look at some of the vacancies posted nationwide on our Harmony Peoples Network this week. First up, Exemplar Workforce is recruiting on behalf of a valued client in the logistics industry. They are looking for a proactive zone controller to join their Cape Town operations team. Destiny Staff Solutions is also recruiting for a logistics company that is in search for a diesel manager to supervise their busy workshop. Last but not least, Holistic Approach is advertising for both a Swift specialist and quality specialist positions in Pretoria. For the full information of the mentioned positions, how to apply, as well as more available positions, find the vacancy link in the description. You will also find a link to a useful video on how to compose a winning CV and have a successful interview. Tune in again next week for more Harmony vacancies.